All right. Well, we've got a few people logging in already. I see a few familiar names. It's good to see you guys. Glad you're joining us today. Give it just a minute while everybody gets logged in. All righty. Well, let's go ahead and get started. Welcome everyone to our webinar Wednesday. I'm glad to have you back with us today. Today, our topic is to be proactive, how to protect your assets and avoid litigations with James Leach as the executive director with Maverick. Before I kick everything over to Jim, I do really quickly want to go over a few housekeeping items. Today's event is being recorded. However, it will not be available on our website. If you do need to visit again, you can contact Scott. His email will be in the announcement you get, the thank you get for joining us tomorrow, if you would like to revisit the webinar or have any other questions. We are taking questions throughout the webinar, so make sure you get your questions asked by clicking on the Q&A speech bubbles down at the bottom of your screen. I will normally hold those until the very end of the event today, and I will read those out loud to Jim for him to answer them for you. If you have questions that are about some technical issues or you needed to communicate with me directly, you can reach me through the chat function, the little chat speech bubble. It's a single one down at the bottom of the screen, and you can click on that and ask any questions you have directly to me if you're having any issues with the Zoom platform. So with that, I'm going to go ahead and get started. Jim, if you could switch the screen, I want to go ahead and introduce Jim. I've had the pleasure of spending some time with him this morning to learn a little bit more about Jim. I'm very excited to have him as our guest today on our webinar Wednesday. He's been involved in the home building industry and warranty and insurance for 3 decades. He is an attorney admitted into the bar in Iowa. He'll be sharing lots of great tips for you, help you ask questions of the people that you're working with when you're making decisions, being able to ask yourself the right questions. Graduated from Duke University, has an MBA and an MI from Georgia State. He's also spent a little bit of time as an airline transport pilot and was originally trained by the U.S. Air Force. And he loves skiing too, is what I've learned. So we've had a great chat this morning, and I'm looking forward to hearing more from him today. So with that, Jim, I'm going to go ahead and pass it over to you to share all of your great tips for us today. Thank you so much for joining us.
Well, Emma Jane, thank you so much. And thanks to everyone who's dialed in. As we discussed, Emma Jane and I discussed earlier, I'm going to err on the side of making this shorter rather than longer. We have quite a number of items to cover, and I'm going to run through them and try to cover them well, but make the points and even try to make them in a memorable way. In some cases, I'll give ask some questions, tell some stories, and so forth. But for starters, I'd like to talk a little bit about the overall theme of what we're going to talk about today, and that is litigation. And why is it that builders care so much about litigation? And if you can see this, I'm holding up a green book. It's entitled Warranties. It's by the 3 lawyer friends of mine from the National Association of Homebuilders, and it does a little history lesson on home builders and litigation and what has happened over the last several decades. So a trivia question for you. What did it cost to build a home in the 50s, just after World War II? Well, it was about $7,000. So if you take that and bring that to present day value, that would be maybe $90-something thousand to build a home, but it doesn't cost that to build a home now. It costs 4 times that much. So this has the attention of courts around the country, and Many decades ago, the law for home builders was caveat emptor, so it was buyer beware. So if you're a home buyer and you're buying a home from a home builder and there's something wrong, well, too bad. You should have had it inspected and so forth. It was buyer beware. Well, courts have looked at that over the last several decades, and they have changed the law on that and made it seller beware. So it's caveat venditor. It's the opposite of caveat emptor. They did that because a home now is probably the most expensive things that most people will buy. And if you know anything about the courts and the court system, they're in the business of protecting the little guy. They want to protect the victim. And so in the case of home building, they're going to be on the side of and protect the homeowner in most cases. And I mention that to you because it's very important in home building that you avoid litigation and avoid lawyers and avoid court. And you're more susceptible to it than others. For example, recently we signed up with Costco. Well, Costco is also B2C, business to consumer, but they're selling $100 items and you're selling $400,000 items. So it's a big difference for courts. And so courts, state by state, in this green book that I showed you, state by state, they have looked at this and established what's called the implied warranty laws. And it means that if you build something, you impliedly warrant that it's going to be habitable, free from construction defect, no problem. Well, that's really a bad deal for you, and you want to replace that potential nebulous exposure with a written contract. So we're going to run through that and why that's important to you and what's the difference between general liability coverage, insurance coverage, contracts, warranties, and so forth. So for starters, with that preamble of why you really care about litigation and avoiding it and why you're more exposed to that than other companies, let's talk about general liability for a minute. So a general liability, your insurance contracts are reactive by definition. So nothing happens until there's a claim or an event or an occurrence, and then that may or may not trigger coverage under an insurance policy. So general liability is going to cover potential tort claims, negligence claims, and so forth. It will cover resulting damages and bodily injury. It's not designed to cover business losses. So it's important to understand the difference between an insurance loss and a business loss. And general liability insurance policy will exclude your work. And that seems strange until you think about it, but your work should affect your profit and loss statement and not trigger an insurance claim. On the right side of this slide, I mentioned loopholes, and I'm going to talk in this for the next 30 minutes about two loopholes you really care about. One is on the insurance side, one's on the warranty side. So on the insurance side, there is a particularly dastardly exclusion. It's the technical name of it is the CG 2294. And if you are a builder, you want to make sure that whether your subcontractors have coverage or not, you do. So if there's negligence of a subcontractor imputed to you, you want to make sure you have coverage. If your insurance policy has the CG 2294, you do not. So it's very important that you deal with professionals in this business, lawyers who understand construction, insurance people who understand construction. This is not Jake from State Farm or Good Hands with Allstate. This is a lot different. And I'm not meaning to disparage Allstate or State Farm, or anyone else. They're fine companies, but mostly they're personal lines companies. You want to deal with someone who understands construction. Now, so that was some basics on general liability. Let's talk about the warranty contract. And we're going to be talking about 4 contracts here, but sort of the cornerstone of a lot of this is a warranty contract. So I mentioned a few minutes earlier from the green warranty book from the lawyers of the NAHB, each state has what is referred to as implied warranty laws. Those are court cases, and they say that if you build it, there is an implied obligation. Well, what the heck does that mean? It means, what a court decides, it means several years down the road. You want no part of that. So be sure that you replace that implied warranty obligation with an express written warranty contract. I also mentioned earlier that caveat emptor was the law many years ago. That's been replaced by caveat venditor. So it's seller beware now, it's not buyer beware. The courts have recognized how expensive homes are and that it's an unlevel playing field. I mean, you as the builder, you're the commercial expert, you're the expert on building. The homeowner is not thought by the court to have any expertise in this area. So the courts are going to side with the homeowner and they're not going to side with the builder typically. So courts are in the business of compensating victims. They want to level that playing field. Now, be careful with a warranty contract. It is possible you can provide your own warranty contract. Be very careful with that because courts don't like it if they feel like you're trying to limit your own liability. A self-serving contract might not be as enforceable as if you have a third-party contract. So it's important that you have a warranty that defines the builder's work. It can also cover the structural defect exposure. Warranties can be proactive. General liability and insurance is always reactive. So we started this seminar saying, be proactive. Well, how can you be proactive? And you do that really with contracts. And we'll talk a little bit about that. So the next point that I would like to make is that in law school, in your first year of law school, you take, constitutional law and civil procedure and so forth. But two courses you always take are tort and contract. And you learn in the business world when there's a problem, it's one or the other. And you, as a business person, as a builder, anyone in this industry, you don't want anything to do with tort. So a tort claim means a negligence claim. It means that something has gone wrong. It's likely meaning litigation. You don't want anything to do with that. You want to make it a contract matter, and you want to send the dispute resolution to ADR, which is alternative dispute resolution. That's conciliation, mediation, arbitration. You certainly want that. You don't want litigation. Now, next 3 slides here, I'm going to do 4 cases, 4 contracts, and then 4 claims. So first of all, 4 classic claims examples. Number 1, a poorly installed water heater breaks suddenly and floods the home. Is that a general liability loss? Well, it is, it should be, and it should be covered. The general liability is not going to cover the loss of the water heater itself, but it'll cover the resulting damages. Number 2, you build a deck on the back of a home, and after a few years, instead of having 5 people on the deck as it was designed, you've got 30 people on there, and the deck collapses and there's injuries. Is that a covered claim? And the answer typically is yes, it is. That would be a bodily injury claim covered by general liability. It might also be a homeowner's claim. It depends. Now, 1 and 2, each of them, that's an event or an occurrence that triggers a claim. So third, classic example, workmanship issues, systems issues. Well, it's very important. That's typically the responsibility of the builder, but very important that the warranty contract articulates what those exposures are. Lastly, number 4, a structural loss from soil movement many years after construction. Now, soil movement. So if you have a soil movement claim and a home has a structural issue 6 years, 7 years down the road, is that a general liability claim? Well, typically that's not, because that's something that has happened over a good period of time, and an insurance claim would be triggered by an occurrence or an event. So Soil movement is very important, and here I'm going to insert in and just ask a quick question. Why is it that the Leaning Tower of Pisa leans? Well, I didn't know this until a few months ago, so I assumed that it was an engineering issue because it was, built 1,200 years ago. But the real reason it leans is soils. The soils in that area of Italy are particularly bad, and not just the Leaning Tower of Pisa. I mean, the whole town leans back and forth. I mention that because soil movement is a big deal in warranties. Be sure that your warranty covers loss from soil movement. 80% of the structural defect claims are going to come from soil movement. So I mentioned earlier on about the CG 2294 exclusion in general liability. You don't want that. Well, a soil movement exclusion in a warranty contract, you don't want that either. So those are 4 very classic claim examples. Now let's talk about 4 contracts. There are 4 contracts that will do the best job of protecting your business. So first of all, kind of a cornerstone contract, we've already talked about it, a warranty. Be sure it's an express written warranty. You don't want anything to do with the implied warranty laws, which will mean a tort claim or litigation. You want to certainly avoid that. Let's go to the right, number 4, the sales contract. You need to have a sales contract that is designed to protect your company, a building company, not really a realtor contract. It won't typically have the language in it that will be best for you. And so important, the sales contract and the warranty contract both have dispute resolution provisions. Make sure they're the same. And I don't mean just similar, I mean really the same. So if you have the sales contract that says if there's a dispute, it'll be resolved by a court of law, not tried by jury. And you have a warranty contract that says it's the Federal Arbitration Act. Well, both of those contracts are contracts with the homeowner, and you would have an inconsistency and therefore a dispute as to how a claim would be resolved. So it is critical that the sales contract and the warranty contract be consistent documents with regard to efficient dispute resolution. Number 3, the subcontractor agreement. That's a document that if you don't have one, ask me for one, I'll send it to you. Doesn't have to be that long. It can be, 5 pages is fine, but quite important to have that agreement. And lastly, general liability insurance. So don't get this from, a personal lines company. Be sure to get it from a company that specializes in construction. Make sure your agent understands construction, because you want to make sure that your warranty contract, general liability, subcontractor agreement, and sales agreement, that they all work together. I'll mention another little story in this regard. A few months ago, a large client of ours, I was reviewing their contracts, and I looked at the subcontractor agreement. It was really good, about 5 or 6 pages long. Looked at the sales contract, 10 or 11 pages long, really good. Warranty contract, typically maybe 20 pages, really good. Then I looked at their general liability insurance contract. It was 109 pages long with 47 exclusions. Now, the reason I mention that is you don't want to have an insurance claim because it may or may not be covered. You might get a reservation of rights letter. Who knows what's going to happen? But it may or may not react to something. You want to be proactive, and you have the ability to do that with 3 of the 4 of these contracts: a warranty contract, subcontractor agreement, and sales agreement. Next. So we did 4 claim examples, 4 contracts, and now let's talk about 4 court cases. So the first one on the top left, the Toll Brothers, and by the way, I'm going to mention Toll Brothers, D.R. Horton, Lennar, and so forth. Fine companies. Don't take anything I say as any kind of a slam on any of these companies. They're all fine companies. These are just court cases that I'm aware of, and they make a point that's important to you. So Toll Brothers, 2018, the Wang family sued Toll Brothers, and Toll Brothers went back to the Wang family and said, well, no, you can't sue us. You are in contract with us, you have to arbitrate a dispute. And the Wayne family's lawyer said, well, wait a minute, your sales contract says arbitration by the Federal Arbitration Act, and your warranty contract says Delaware Arbitration Code. Which is it? Well, the court threw that out and made the Wayne family litigate a matter with Toll Brothers. A similar case in 2006 in South Carolina, DRH is D.R. Horton. The Smith family tried to sue D.R. Horton. D.R. Horton said, you can't do that. You have an arbitration clause with us. And the court looked at it and said, well, it's actually too self-serving. It's too heavy-handed by D.R. Horton. And so they made it a litigation matter. So that's those are just a couple of instances there to be aware of. Consistent contracts are important. Don't try, be very, very careful about do it yourself. Courts will view that as one-sided, self-serving by you, may or may not work. On the right side of the screen, a couple of Supreme Court cases that are a really big deal. So there is a thing called the Federal Arbitration Act, and that's been around since 1925. So it's been good law, quite literally, for 98 years. In January of 2019, Justice Kavanaugh's first opinion of the U.S. Supreme Court, the question was, if you have the Federal Arbitration Act in your contract, is that enforceable? U.S. Supreme Court 9-0 decision said yes. That's a big deal to you because home building, like Costco, is deemed to be interstate commerce. And if you're interstate commerce, you can use the Federal Arbitration Act. So I would recommend that in your language, as opposed to typically a state arbitration code, which may or may not be as friendly to you. The Federal Arbitration Act, again, been to the U.S. Supreme Court at least a dozen times that I know of and always upheld. 4 months after that, in April 2019, the question to the U.S. Supreme Court was, if you have the Federal Arbitration Act and class action waiver language, is that enforceable? And the U.S. Supreme Court 5-4 decision said, yes, it is. That's a really big deal if you're building a lot of homes. So if you're a larger home builder, and let me just give you two other quick cases here on this that are just very instructive. About 2 months ago in South Carolina, D.R. Horton was sued by 220 former homeowners in South Carolina, a class action by them and for various construction defects. And the result of that, public information, again, I'm not disparaging anyone, public information, $16.1 million settlement against D.R. Horton. Compare that to a case of about a year and a half ago in Florida. Lennar got sued by the Martinique Homeowners Association. It was a case that was brought by Morgan & Morgan, and they were representing hundreds of former homeowners and the HOA. Lennar said, no, you can't do that. Each of the homeowners is obligated to arbitrate this and obligated to not join a class. Lennar lost that case at the trial court level, but they won on appeal. And that's a really important thing. And let me just read you this language for just a second. You hereby agree that you will only bring a dispute in your individual capacity, not as a plaintiff or class member of any purported class. You expressly agree not to maintain a class action in any forum, but you agree to have every dispute decided individually through arbitration. Is that language enforceable? And the answer is, according to the U.S. Supreme Court, yes, it is. So use the Federal Arbitration Act, make it a contract matter, make your contracts consistent, and you will have done the best job you can of avoiding litigation. So the next slide here. First of all, at the top, litigation in a court with jurors and uncertainty. It's also public. Arbitration is typically in the home with a construction expert, and it's private. Litigation, much more expensive. Arbitration, much less expensive. And you're probably going to be dealing with a professional construction person as the arbitrator. So am I a huge fan of arbitration? Well, not really. Company I was with years ago, they had 1 year we had 200,000 incidents, many of them which could have been claims, and only 7 of them actually went to arbitration. So you don't really arbitrate that much, but you certainly want that as a full stop so that you can't get to litigation. You want to avoid litigation at all costs. You know, again, courts like compensating victims. When you're fighting against lawyers, you know, tort means court, and you're going to be stuck in their home and not yours. You certainly want to avoid that. Some summary of some key points that we've just talked about with regard to warranties and contracts. So, number one, we discussed this earlier on. You warrant your work, like it or not. Caveat emptor, buyer beware, no longer the law. It's the opposite of that now. So get rid of that tort exposure, the implied warranty exposure, make it a written warranty contract. Number two, each state has their own court cases referred to as the implied warranty laws. That green book that I held up earlier, it has a summary of the court cases in every state. So you want to make sure that you are avoiding that potential litigation, because you're on the hook for what you build, not for a year, but until the end of the statute of repose. National average is 8 to 10 years. Some states it's as short as 4, you know, like Tennessee, but most states it's 8 to 10 years. Inconsistent contracts. Remember the Toll Brothers case. The Wayne family sued them. Toll Brothers said, no, you can't sue us. You have to arbitrate. But their contracts were inconsistent, and so it ended up being a matter of litigation. Number 4, contract or a tort. Tort's not your friend. Tort means court. You don't want anything to do with that. Make sure that it's a contract matter. And number 5, 4 key contracts will best protect your business. Sales contract, a consistent warranty contract, the subcontractor agreement, and general liability insurance. There are others, but I would say those are the big 4. So number 6, litigation is very expensive. It's public, can hurt your reputation, uncertain outcome. Arbitration is private and perhaps 10% of the cost of litigation. Contracts will articulate that dispute resolution is other than litigation. And like I said, if your contracts are consistent in that regard, you've done a really good job of avoiding lawyers and litigation. Number 8, the Federal Arbitration Act. This says good law for 95 years. It's actually 98 years. So a conciliation process, a mediation process, you know, that's the way to resolve a dispute. And then binding arbitration if you absolutely have to go there. Class action waiver language, is that enforceable? Yes, it is. So you want to have solid contracts, send your dispute to somewhere other than litigation, and make it a contract issue, make it mediation and arbitration. A third-party warranty contract, I typically would recommend those. Courts don't like do-it-yourself. They don't like self-serving documents. If it's a 2-party contract and if there's any kind of wiggle room at all, again, the court's likely not going to side with you. General liability. So a few key points we talked about in general liability. First of all, understand a business loss versus an insurance loss. A business loss is going to affect your profit and loss statement. An insurance loss is going to be triggered by something unexpected, an occurrence or an event. Your work, not covered by an insurance policy, not designed to be covered. So number 2, with general liability, think about it as a tort claim. It's a negligence matter. And I hope that you will have addressed that upfront proactively with a contract. There is a your work exclusion in the general liability policy. Well, that's as it should be. Your work should affect your profit and loss statement, but it shouldn't really trigger a general liability claim. Now, that said, there are a number of states out there where faulty workmanship may trigger a general liability loss, but the textbook answer is it does not. General liability is triggered by an occurrence. Poor workmanship is not a trigger. Soil movement over a period of time is not a trigger. General liability is also going to cover resulting damages and bodily injury claims. And then I mentioned also the difference again between a third-party warranty contract, which will cover things like structural defect claims. Those are claims that are typically not covered by a general liability insurance contract. Summary now of general liability versus warranty, summary of why you want to be proactive. General liability covers negligence claims, tort claims. A warranty is going to define your responsibility. It will take you out of potential tort claims and implied warranty obligations. A warranty enables you to have a long-tail transfer of structural exposure to a warranty contract. Most importantly, on the right, a warranty contract enables you to be in contract with your homeowner. You've got two contracts with your homeowner, your warranty contract and your purchase and sale agreement. Just make sure that your dispute resolution language in each of those is consistent. Claims example, I mentioned 4 of those. We talked about tort versus contract. Be sure that you have an express warranty contract, not an implied warranty obligation. Be very careful about doing it yourself. Now, lastly, a quick visual for you. So let's talk about asset protection, a builder's view, and then we'll talk about a risk management view. So from a builder's standpoint, a home builder, you're building a home and you want to protect what's inside that home, the family, the appliances, furnishings, and so forth. You want to protect from hazards in the environment. You're concerned about termites, fire, soil movement, storms, etc. Well, how do you do that? First of all, it's with a foundation, fill, piers, concrete slab, basement, and so forth. Then you have the roof, ceiling joists, rafters, insulation, and so forth. You connect it all together with the envelope, the framing, the wrap, the cladding, and so forth. Let's look at asset protection from a risk management standpoint. So in this case, let's say that the home builder is the client, and how do you protect the assets, the reputation, the retirement, and so forth of the home builder? How do you protect them from tort claims, court claims, disputes, soil movement, and so forth? Well, it's the same answer: a foundation, a roof, and an envelope. So in our world, the foundation would be contracts, warranty contracts, sales contracts, subcontractor agreement. The roof, insurance coverages, general liability, builder's risk, workers' comp, auto, cyber, and so forth. And then you would have an envelope that would be designed to tie that all together. Coordinated contracts, up-to-date language, Federal Arbitration Act, understanding of adversarial trends. And remember, the Lennar case versus the D.R. Horton case. D.R. Horton, the lawyers were able to get to D.R. Horton's assets, 16.1 million. In the Lennar case, they forced all of those claims into individual arbitration. And that's what you want to do. If you do your contracts correctly, you can do that. So I'd like to say here at the end, a quick disclaimer. I am a lawyer. I'm admitted to practice. It's likely I'm not admitted to practice in your state. So don't take any of what I've said to you as legal advice. I don't provide legal advice, but we give you a lot of tips here things for you to be aware of and familiar with, and just trying to find ways to avoid keeping you in trouble. Keeping you out of trouble, of course. So I'll end with a couple of quick stories. There was a homeowner, his name was Gus. He lived in New York City, And Gus decided he wanted to move to a quaint little village up in New England. And he goes up, finds the village, finds the home, makes a deposit on a home. He's all excited about it. And the next thing that happened was Gus hired a home inspector, an architect, to go in and make some recommendations in the home. And Gus's first inclination something was wrong was when the home inspector refused to enter the home. Well, he asked why, and the home inspector said, well, that home is haunted. And so Gus was not very happy about that, and he calls Penelope, who was the seller, and said, what's this all about? Penelope says, well, it's no big deal. This little ghost has lived in the house for a long period of time, and worst thing that ever happened was, he ate a ham sandwich once, but, really no problem. Well, it turns out it was a big deal. Penelope had written articles in the local paper about the ghost, and she wrote an article in Reader's Digest about the ghost. And so Gus said, well, enough of that. I'm not buying this house. Well, Penelope, of course, says, caveat emptor. This is, several years ago, back in the day when that was the law. So how do you think the court ruled in this case? Well, in this case, they ruled in favor of Gus, because if you recall from earlier, courts are in the business of compensating victims and protecting the little guy. And in this case, they viewed Gus as the victim. And a couple of interesting things in this case. One is the court said that the home was haunted as a matter of law, which I always found strange. I never heard of such a thing. But then the judge also said, in his ruling, he said, the real answer is, who are you going to call? And he said what he meant by that was, it's reasonable to call a home inspector or a termite person and so forth to buy a home. It is not reasonable to think that you have to call a psychic or Ghostbusters. So in this case, the court overruled caveat emptor and ruled in favor of Gus. So to back up and summarize and end this, the reason why you care about your contracts and everything we just talked about here is you don't want to have anything to do with court cases, and you don't want to have anything to do with the implied warranty laws. You want to make sure when something goes wrong, it's a contract matter. You're not Costco because you're not selling $100 items. You're selling the most expensive thing that most people will ever buy. So be sure when something goes wrong, it's a contract matter, and it's not going to be a tort claim or litigation. That can hurt your reputation. It's public, it's expensive, and you can avoid it by being proactive. So with that, Emma Jane, do we have questions?
So I have one question so far. That was fantastic, very informational. I'm so glad we were able to have you on today. But our first question comes from Andrew. He says he uses a separate LLC for the owner on the title than he does on the contractor on the permit, but both entities he manages. In the event of a GL event and claim, what entity needs coverage? The contractor, the owner, or both?
Both, but let me say that may be a state-specific question, and it would be, I would talk to your lawyer in whatever state you're in about that. Short answer with regard to LLCs, I recommend them. It's another layer of protection. So all your insurance contracts are a layer of protection. A warranty contract's a layer of protection. Sales contracts, another layer. An LLC can be a layer of protection. Also, if you are dealing with HOAs, potential class action, your contracts with HOAs and how you deal with them can also be another layer of protection. So LLCs, is that a good idea? Yes, it is. But his question is probably state specific, and I would ask his local lawyer about that.
Excellent. That's great. Great to know what kind of questions to ask always. Thank you so much. We have another question coming in from Richard. What do you recommend a builder do for future protection when they are retiring from the business?
Wow, that is a really good question. Uh, my advice would be I'd talk to a really good lawyer and I would talk to an excellent insurance agent. Sometimes you can buy coverage for tail exposure. In other words, if you're retiring and you've just built a home and you're in a state that has a 10-year statute of repose, you may still be on the hook for several homes that you just built for several years. So it's possible that your previous general liability insurance policies will cover that and also cover the tail. Just be sure, and like I said, the biggest advice I would give is talk to a good lawyer, talk to an excellent insurance person, and tell them that you're retiring, tell them about the exposure, and just make sure you have it covered. I hope that as you were building homes, that you had a solid warranty contract and a solid sales contract, because if you have problems down the road, you don't want those to be insurance claims. You would rather them to have been contract matters.
Excellent. Thank you so much. I hope that answers your question, Richard. I don't have any other questions at the moment. I do have one from Georgiana. Greta, thank you so much. They've appreciated your presentation. It was very helpful. So I guess, well,
I will, Emma Jane, I'll finish up
yeah.
with two quick questions that are related to this. One is, what killed the Beatles? And number two is, what did the Wright brothers do wrong? And the answer to both of those questions is litigation. So the Beatles, they started off by hiring a fairly inexperienced manager, and they cut a lot of deals, a lot of merchandising deals and so forth. And what really hurt them over their career, there's a big article about this in the American Bar Association Journal a couple of years ago. What really broke them apart was litigation. It got so intense. George Harrison and Paul McCartney didn't pick up a guitar for a couple of years. So the point of that is litigation can really knock it out of you. And then the Wright brothers were brilliant in what they did. They figured out, forward motion and, lift and all this kind of stuff. They had a hard time figuring out how to turn an airplane. And so when they learned how to fly, they patented everything. And when there was a breach of one of their patents, they would sue. And so the biggest thing that the Wright brothers did wrong was litigation. And the point is, I'm a real fan of the Wright brothers and Beatles, but not a fan of litigation. And it was, a real tough thing for them, particularly important to home builders. You don't want anything to do with implied warranty laws or court cases. And you can protect all of that if you do your contracts right.
Hey, Jim, I have a question for you, because a lot of the builders have these 210 warranties that have been around since the 70s. Are they protected? I mean, that's a third-party warranty, but I don't know if it really is protection, or because it got started as basically a marketing program.
Yes. So there are 4 or 5 companies that provide third-party warranties. I recommend them. Be very careful with those, because more often than not, the dispute resolution language in your third-party warranty contract won't match up with your sales contract. And be sure to take a close look at that and deal with a pro, an insurance agent or your lawyer and so forth. Make sure they do match up. So 210, I'm very familiar with them, worked with them for a long time. They cover structural defect claims. Like I said, there's 4 or 5 third-party warranty companies out there that do that. I do recommend them. I recommend a third-party warranty contract, but just be very careful with the dispute resolution language. Your biggest exposure likely is not to a structural defect claim, but to a potential litigation claim. And so you want to make sure that your language there is aligned.
Yeah, I don't know if anybody's really paid attention to that.
Well, most people don't pay attention to it. I mean, I look at these contracts all the time, and they are, 95% of the time the language is inconsistent, and therefore there's a potential exposure. So you're right. People should pay a lot more attention to that.
Yeah, because I think that what they do is they just buy the 210 warranty or the HAL warranty or whatever the warranty is. And
Yes,
don't really look at the details of the agreement.
you're exactly right. And the details are very important.
Thank you, Chuck. You have a couple of thank yous from Albert. Thank you so much. It was very helpful. And Brad agrees, great information. Thank you so much, James, for your time today. That is all the questions I have for today. I really appreciate the time I've had with you this morning. It's been very enlightening, very informative. I know there's a couple people who arrived late. If you were not able to get on right away, go ahead and contact me. I'll put you in contact with Scott Franco, and he can help you if you have any other questions, or you can also contact Jim directly at jleach@maverickbuilders.com. So thank you again for joining us today. Thank you, Scott. Thank you, Jim, for your time this morning, and all of you who are here with us today live. And I look forward to seeing you again at another webinar Wednesday. Next week will be with ECI. So we look forward to seeing you all next week.
Emma
Thanks
Jane,
again.
thank you. And thanks everyone.
Thank you. Have a great day. Thank you, guys.